So we are going to record. So just remember that. And again, if you haven't changed to speaker view or side by side, please do so. Please remember to receive credit. You do need to fill out this trustee form and get it back to us as soon as possible. It is a two-parter, so make sure we get both of those back if you can. Send it today to Lori's email, which is info2. Please keep your video on, and if you're not on, again, remember that I will be chatting with you just to confirm that. And I did just get a message from Steve. I will send you the materials. You should have gotten them this morning, but I will send them again in case it didn't go through. I sent it off of Lori's machine because she's out. So, okay. If you are on the phone only, which I'm not sure I have anybody, because like I said, your screen is supposed to be on, or at least come on for occasional time so I can check that to make sure that you're there. If you would, when Attorney Best starts discussing retirement benefits, please note the time on your CLE form. That way that we know that you were present. Make sure you're muted if you're not. If you have questions, you can put them in the chat. In the meantime, Patrick will try to answer them as he goes, but generally it's at the end for most of our presenters. Patrick's real good at catching that, better than most, which just shows he's a lot more in tune to Zoom than the rest of us. And following the presentation, if you do have questions, we'll get those answers to you. And do not, again, I'm going to remind you again to fill out your trustee form so that we get that credited for you. So with that, Patrick, I did do the screen sharing option, so you should be good. And okay. I'm going to turn it over to Attorney Best. Thank you.
All right. Thanks, everyone. Today, we are talking about Social Security and Social Security disability. I structured this course as a basics program so that anyone who may interact with Social Security but doesn't necessarily practice within the realm of Social Security would be able to gain some additional familiarity with the program, all the different types of options that are available, and how it may interact with your individual practice area. As Denise mentioned, I do like questions. I'm happy to answer anything that you may have, so feel free to drop it in the chat and I will get to it as I see it, but otherwise I will move forward. So the Social Security program generally. This obviously was a long-standing program. Many of us were not around at that time. It was signed originally into law by President Roosevelt in 1935, but since that time it has undergone a number of additional changes, many of which you have become very familiar with. So we'll talk about some of those coming forward, but like Medicare was an expansion of this. They continued to grow out who may qualify for Social Security and what different programs were offered. The concept of the program generally is that it's paid for by taxes from payroll. The main source of revenue for the Social Security program are the FICA taxes, which are the ones that are directly taken from your paychecks. If you're self-employed, generally speaking, they're going to be taken in the form of self-employment tax, which was paid through your Schedule C, but conceptually it's the same thing. You are paying for the benefits based on your earnings up into a certain point, and therefore that gives you access to the benefits of the program. The original provision was meant to pay retired workers that were over 65. And again, that was in response to the Great Depression at the time. Since that time, it's been expanded multiple times to include additional retirement benefits, disability benefits, survivors benefits, and widows benefits. The two ancillary programs are Medicare and Supplemental Security Income, or SSI. A lot of people talk about SSI kind of in the same way we talk about Social Security. It is a different program. It is funded differently, but it is very much so related. It covers a lot of the things that Social Security does, but it's much more of a means-tested program. So it's really meant to cover people who may not qualify for Social Security or to supplement people who may need additional benefits other than Social Security. The concept of retirement benefits. So here, what we're doing is we're replacing a percentage of your pre-retirement earnings based on your lifetime earnings. Social Security takes the highest 35 years of your earnings and puts together this package for you, which starts when you elect to take your benefits and should continue for the rest of your life. It works very similar to the concept of a pension, but it is based on your earnings. So everybody can get a different amount depending on how much they've been making over time.
I tried to do it last week and I went, no. So I'll be back in a little while. There is traffic out there. So
Okay,
I'll be right back in a little bit.
right.
When you work and pay Social Security taxes, you earn credits towards Social Security benefits. These credits are sometimes called quarters of coverage. It is very similar to the concept of paying an insurance premium. The number of credits you need to get to retirement benefits depends on when you were born, but most people that we will talk to now, because if you were born in 1929 or later, the answer is 40 credits. So for the most part, we're only going to interface with people who need 40 credits. That is 10 years of consistent work, but it does not have to be consistent. You can earn a credit in 1 year and then take several years off and come back and earn another credit. You just need a cumulative total of 40 credits. And you cannot earn more than 4 credits in a year. The amount you receive varies based on how much you earned during your working career. So the more money you make, the higher your benefits will be. There may be times where some years you had lower earnings, some years you had higher earnings. That will be averaged. It's not averaged in the arithmetic sense where we just add everything up and divide it by the number of years you worked, but it is averaged in the sense that if the years that you had lower amounts are going to be considered, and which may lower the amount of money that you would get in your benefit. It's also affected by the age that you choose to retire. So many of you know that you do have the ability to elect early retirement at age 62, which I'm going to go over in a minute, all the way up through age 70. So you can, at any point, elect to retire, and that'll affect how much you get. In fact, you can see here exactly what that would look like for the early retirement. So I got this chart directly from Social Security. There's a couple things to look at here on this chart. So the first is you'll see full retirement age varies. If you were born in 1960 or later, it is 67. But you will interface with people, or you may be one of those people that was born before 1960. In that case, your full retirement age may not be 67. It may be 66 and 10 months, all the way down to 66. Full retirement age is the age at which you get the full, not reduced, retirement benefit. If you retire before that, there will be a reduction. If you retire after that, there will actually be additional monies that you can get. You can see also in this chart here that if you elect the early retirement, you do get a reduction of anywhere between 25 and 30%. So if you were going to get a $1,000 retirement benefit at age 67, you elect benefits at age 62, you're going to get that 30% reduction. So your benefit would only be $700. You would also, if your spouse is getting benefits on your earnings record, you would also get a reduction on your spouse's record. This is one of the questions I get quite a bit. I get it in several contexts. I get it in the divorce context. I get it in the bankruptcy context. I get it in a lot of different ways. But if you're going to take the reduction, why would you take it at all? And this is just a mathematical question. Sometimes it's better mathematically to take the payment at age 62, even though it's a reduced amount. And the reason is very simple. Taking the benefit at age 62 guarantees that you'll be getting it for an additional 5 years. So that's 60 payments. 5 years is 60 monthly payments. Even at a reduced amount, it's entirely possible that you make out better taking the early retirement. It's going to depend primarily on whether or not you want to continue working, and while we don't have a crystal ball, what your life expectancy would be. If we knew when we were going to die, this would be a very easy mathematical calculation. Unfortunately, none of us do. I should mention before I move on, the early retirement can be affected by working, but once you hit your full retirement age, it's not. So I have a lot of clients who hit full retirement age, elect their Social Security benefit, and then can work without any problems. However, there are working limitations if you elect early retirement. So that's something to consider. Family benefits. So in the retirement benefit world, Social Security does offer certain family benefits. If you get Social Security retirement benefits, some of your family members may also qualify. If they qualify, your ex-spouse, your child, they can receive additional monthly payments up to 1/2 of your retirement benefit. And that's why, going back to this chart here, you can see what the spouse's benefit would be, because a spouse can collect money on your earnings record up to 1/2 of the amount. The payments that your family members get do not affect your payments. It's a common question I get all the time. If my spouse takes benefits under my earnings record, does it change my benefit? It does not. It is just in addition to. The spousal benefit. So even if your spouse has never worked, your spouse may be eligible for benefits based upon your earnings record if they are at least 62 years old. They can also be eligible for benefits under your earnings record if they are caring for your child under age 18 or who became disabled before age 22. These are a lot of rules, but I'll be very honest with you guys that whenever any of these like complex situations come up, I just look it up. These are not things that I memorized. I understand generally how the programs work, but I hop on the website and I'll be very honest that the Social Security makes it very easy to try to find all these different rules and the nuances. They publish all of their manuals. They publish everything. So if you ever have a case where like, gee, I don't quite remember if this person's going to qualify or not, it's really easy just to look it up. It can get a little complex, but as long as you recognize here that your spouse can receive a benefit under your earnings record, but also if they're caring for a child, they can collect under your earnings record. Moving on to children. So when you qualify for retirement benefits, your children may also receive benefits on your earnings record. Children is a very expansive word within the Social Security context, so it does include biological children, adopted children, or stepchildren. It can also include a dependent grandchild. So it is very, very expansive. In the family law context, this does come up very frequently because there's a question of blended families, or you'll get a lot of grandparent rights cases or things like that where this may come into play. But you can get benefits under the retirement program for your children. To receive the benefits, it's only a few rules. The child must be unmarried, under age 18, or between 18 and 19 and a full-time student, or 18 and disabled when the disability started before age 22. Generally, the benefits stop when the child reaches 18 unless they are disabled or they are still in school. Divorced spouse benefits. So this is another one that comes up quite frequently in the family law context. It's a question of whether or not a divorced spouse can collect on your earnings record. And in certain cases, they can, which can be very helpful for settling a divorce case. If you have not applied for retirement benefits, but you can qualify, so it means you're over 62, you have not applied, but you can qualify, your ex-spouse can receive benefits on your record if you have been divorced for at least 2 years. If you remarry, your ex-spouse will still be eligible. However, if your ex-spouse remarries, they will no longer be eligible. So those are things, remarriages are definitely something to consider in terms of planning. I've been getting a lot of divorce issues where people are getting divorced and there's a question of whether or not they could get remarried. And this limitation is relevant if you need to collect benefits on your ex-spouse's earnings record. Widow's benefits. So we do provide additional benefits for a widow or widower, provided that you meet certain conditions. So generally speaking, you would need to be over age 60 in order to collect widow's benefits. But they do offer it early if you're over 50 and you are also disabled. We see this in cases where a person may not have worked or may not have worked enough during the marriage in order to qualify for benefits under their own record, but they still are I guess the best way to phrase it would be they're not capable of working, but they don't have the earnings to collect on their own record. In those cases, we would use widow's benefits or widower's benefits in order to qualify. You can see there's a lot of different rules here. Other rules including whether or not the widow or widower is caring for the worker's children. They can receive survivor benefits. Survivor benefits are for if you have not remarried and you take care of a deceased worker's child, those will help you take care of that child. And the remarriage rules are a little different here as well. So if you remarry after you reach age 60, then the remarriage does not hurt your eligibility, but the age does matter on these. And this is another one where I'll caution you, if this is something where your client's thinking about marriage and isn't sure, I would double, triple, quadruple check the rule here, because once you lose the benefits, it's nearly impossible to get them back. I will say though, I have handled some divorce cases where the parties were seeking an annulment for a reason very similar to this. A divorce doesn't necessarily put you back into eligibility for these benefits, but an annulment can, because an annulment is a judicial decree that the marriage never occurred. And Social Security will honor that. Although obviously, for those of you who practice divorce, I think you know that annulments are pretty rare, but they can be done. Surviving divorced spouse benefits. These are related to a divorced spouse of a worker who dies. In order to be eligible for this, they add one additional requirement that your marriage has lasted 10 years or more. So it would basically work like this. You're in a marriage that lasts longer than 10 years, you get divorced, your ex-spouse dies, you can, in certain cases, collect on their earnings record if you're disabled or if you reach age 60. Any questions on retirement before I move on to the disability programs? Because I think while related, they are different. So I just want to make sure if there's any questions on the retirement programs that we touch on those. Okay, you can pop them in if you think of something later. I'll monitor the chat. Disability programs. So there's a lot of these, and many of these you probably won't interact with, although for a lot of people, they become very, very important. The ones that you will see very frequently are the Social Security Disability Insurance, the SSDI. Sometimes we just call it SSD. Other times we'll call it DIWC, or a Disabled Insured Workers Claim. Those are all really the same thing. The other thing that we'll see pretty frequently is the SSI, the Supplemental Security Income, which conceptually requires a lot of the same stuff, except it's based for people without a significant earnings record and is a means-tested program. There are offshoots of these programs, such as the Disabled Adult Child Program, the widower, or surviving divorced spouse program. There are special rules for blindness, and there are special rules for children. A lot of those are much less used, but as I said, they can be very important. So the disabled adult child program, for example, that applies when your child has a disability that began before age 22. So it's either a childhood illness or maybe a genetic condition, though they weren't able to work. So they weren't able to build up their own credits. And that program allows us to use the parents' credits. Moving on to the main program here, SSDI, Social Security Disability Insurance. This program pays what we call disability insurance benefits, or DIB, to qualified individuals. It is different from SSI, although if you listen to people, they will use them interchangeably. A lot of my clients don't even know what they're on. They'll call me and say, hey, I'm on SSI, and I look at the paperwork and no, they are not. So it is important to know that they're different. Sometimes it matters for a client, and sometimes it does not, but they are different, and you should be aware that they are different. The SSDI program functions like an insurance program. You pay into it. You're basically paying your premium. It gives you access to the program. These are often called Title II benefits because they fall under Title II of the Social Security Act. And the amount of the disability benefit is the same as a full unreduced retirement benefit. So if that person were to continue to work to age 67 normally, whatever they would have received in retirement is what they're going to get on disability. So people will ask me, well, do I lose money by going on to Social Security disability? And the answer is, generally speaking, no, because if you were to retire at age 67, it's the same amount. I'll get calls from people who are 70, 72, 78 telling me they can't work anymore and they want to go on the disability program. Well, we can't, because you're already older than 67. So just take the Social Security retirement if you're not taking it already. There's no benefit to taking Social Security disability insurance if you're over 67. In fact, I don't even think they'll process the application. Supplemental security income. So this is the needs-based program. It does provide disability income for people of limited income and resources. It is means tested on both counts. So they test your income and they also test your resources. You can be disqualified on either. So it's possible that you're working and making too much money but have no assets and be disqualified. It's equally possible you have too much in terms of assets, even if you have no income. You could be disqualified for either. They are pretty unforgiving requirements. There's a lot of groups that are advocating for increases to the resource limits and the income limits. You may have heard of things like the marriage penalty. There's a lot of disability groups that are really angry about the resource limit and the income limit, but as of right now, that's where we are. So it's a means tested program. The other thing that SSI provides is they provide income to people who are over 65 or who are blind and who may not have enough in Social Security or may not have any in Social Security because they didn't have a sufficient earnings record and don't qualify for any other programs. This amount is not based on earnings. So unlike the Social Security disability insurance program that is based on what you're doing in terms of work, this one is set by the government. We have what we call the federal benefit rate. It does change basically yearly. Right now it's $7.94 a month. That is what you get. You get the federal benefit rate. You may get a state supplement. Some of the states I work in have a supplement, but Pennsylvania does not. And there could be offsets or other reasons that you may not get as much. So if you were working part-time, for example, you may not get the full $7.94. You may get a partial reduction. SSI benefits are operated under Title 16. So you may hear these as Title 16 benefits. The question in the chat regarding the income and resource caps, I do know them. So the resource limit is $2,000 for a single person and $3,000 if you're a couple, but there are exclusions. So generally the big exclusions we use are the house you live in and one vehicle. So you can have a fully paid off house and you're fine. You can have a fully paid off car and you're fine. I have just about everything else. There's a lot more exceptions, but just about everything else is going to count towards that $2,000 or $3,000 resource limit. Income's a little different. They treat different types of income differently. The first $20 per month you get for free. And then there's a dollar for dollar offset for most types of income. So if you made $100 in a given month, they're going to deduct 80 from your benefit. You get $20 for free, and then they deduct the other 80. However, they do want to incentivize you to work. So they actually give you a better deal if it's wage income. If you are working, instead of giving you $20 for free, they give you the first 85 for free. And then instead of doing a dollar for dollar reduction, they actually do a 2 for 1. So for every $2 you make, they only deduct 1 from your benefit. So it is possible to make $500, $600 a month while on SSI and still get a few $100s a month in benefit. So it is preferred. Work income is preferred to other types of income in SSI. Comparing the two. So these programs have the identical definition of disability. If you are disabled under one program, you are disabled under the other, period, full stop. It is the same definition. I can spend a full day on disability benefits and the disability process, but this is a basics course. So I'll give you the very brief explanation that disability is defined as being unable to work. That's what it is. There's rules on how long that has to last and what does it mean to not be able to work. But generally speaking, we're looking to see if you have the ability to engage in any type of substantial gainful employment in the national economy. They use a 5-step sequential evaluation process to determine if you are able to work or if you are qualified for benefits. And while this does get a little bit more detailed, this breakdown I think is pretty easy. We ask first, are you working? Substantial gainful activity changes on a year-to-year basis, but it's about $1,200. If you're making more than $1,200, you're not disabled. The example I always give to my clients is you could be quadriplegic. You work 1 hour a month, but in that 1 hour you make $1,300. You're not disabled. And the reason is because Congress said so. That the rule is if you make more than that substantial gainful activity amount, you're not disabled by definition. Step 2, they ask if we have a severe impairment, which is really an impairment that affects your ability to work, and whether or not it's going to last long enough or result in death. This is not a short-term disability program. We use step 2 to screen out short-term impairments or impairments that really don't affect you. Step 3 asks whether or not you meet one of what we call the listed impairments. You may see on Social Security's website, or your clients may ask you and say, I meet the requirements, I read it online. If they say that, they normally mean that they read the listed impairments at step 3, which give very, very specific medical conditions that meet the definition of disability per se. I will tell you, it is not common to meet the requirements because you have to meet them exactly. If you miss one thing or just a little bit shy on another, you don't meet it. You might be very close. You might, what we call equal that impairment, but that is not, it's not a given. And many people are a little surprised when I tell them that most people don't meet those listings. Step 4, we ask if you're capable of performing anything you've done in the past. If you are, then you're not disabled. And then at step 5, we ask if you're capable of adjusting to any other type of work. And that's really where we're able to prove disability for most of our clients. And this considers a lot of different things. It considers your client's age, education, experience, the specific medical conditions they have, And it's a really specific and tailored analysis to determine if there's any type of work that this particular person can adjust to with all of these different things considered. Disability in healthcare. The other thing that we get asked about all the time is how each of these programs, SSDI, SSI, how they affect healthcare, give you healthcare, interact with healthcare. So briefly, it's actually pretty simplistic. If you're on SSDI, you are eligible for Medicare. You get Medicare eligibility 2 years after you become eligible for SSDI benefits. If you are on SSI, you are eligible for Medicaid. That eligibility is immediate. If you are eligible for both programs, SSDI and SSI, you may be eligible for both Medicare and Medicaid. That is possible. Generally speaking, clients who are eligible for both SSDI and SSI end up losing their Medicaid eligibility when they become Medicare eligible. But it is possible to be eligible for both of those programs. Question about the substantial gainful activity limit. Is the 1,200 or so a month threshold gross or net? And it's gross. It's gross. That's the other thing that happens to my clients a lot. They'll come in and they'll say, but look at my paycheck. And they're not considering the fact that it's the gross amount. And they end up being disqualified because of that. All right, so looking at these healthcare programs in a little bit more detail, looking at Medicare. Medicare is a health insurance plan for people who are over 65, and that is regardless of whether or not you're disabled. You can get Medicare at age 65 or regardless. In fact, you can get Medicare at 65 regardless of whether you are enrolled in another insurance plan. So it's entirely possible that Medicare is either your primary and you have a different secondary, or more often you'll have a primary insurance and Medicare will act as your secondary insurance. To be eligible for Medicare, you need one of a few things. You either are 65, you're disabled and have been for 24 months, or you have end-stage renal disease. Generally, when we apply for Medicare, there are a few different parts. We have Part A, which everyone gets. So when you're 65, you're going to get Part A. It's free. That covers most inpatient hospital treatment. Again, there's no additional money. You're just going to qualify for that. It also covers 100 days of skilled nursing. And I'll circle back to that in a minute, why that's important. Medicare Part B that's your general outpatient services. That's your primary doctor, your specialist. Most of the things are going to be covered under Part B. Part B is not free. It's very cheap. It's only like $100 and some a month, which for insurance is pretty good, especially for people who are over 65, but it's not free. So you do pay for it. Most people who get it are on Social Security. If you're on Social Security and you elect Part B, they normally just take that money out of your Social Security check. So it'll just slightly reduce your Social Security benefit. Part B, in my experience, Part B is very comprehensive. It does cover a lot of things. It is not perfect. One of the things that I'm not covering in a lot of detail today, but is very important for people who have the ability to pay for it, are Medicare supplements. So there's a lot of people, and I mean, you may have seen or heard, like there's a lot of really common supplements, like AARP sponsors a supplement. It's a private insurance plan. So to be clear, these Medicare supplements are just private insurance plans that are intended to fill in the holes of Medicare. Medicare very famously, or I should say infamously, has what we call the donut hole. They cover you up to a certain point, then they stop covering you, and then they'll cover you again when you get over a certain point. A lot of those supplement plans target the donut hole and they try to fill that hole for you so you don't feel the pain caused by that portion of uncovered medical expenses. Medicare supplements are typically inexpensive. They do cost money, so people who don't have a lot of it typically don't elect to get them. But if you have a client who's a little bit more comfortable in retirement, it can be very, very worth it, especially if they do have high medical expenses. Part D is the prescription drug plan. This is relatively new. This was actually enacted by George W. Bush, so it's not even really around that long. Is optional, costs money. You have to elect it, but it covers prescriptions. From my experience with it, it actually covers quite a bit. In Pennsylvania, we also have PACE. So a lot of my clients in Pennsylvania don't necessarily elect Part D because sometimes PACE is better, but that's something that you would have to shop for and determine what's better for you. Additionally, if you happen to get a Medicare supplement, some of them do cover the prescriptions as well. So there's a question of whether or not you need Part D. For some people, it works out really well. For some people, it does not. Worth noting here, I mentioned skilled nursing. Skilled nursing is covered by Medicare Part A for 100 days. That's important. And the reason it's important is because people think that nursing homes or skilled nursing facilities or things of that nature are going to be covered by Medicare. They are not. Their first 100 days may be, and even then, those requirements are pretty strict. They have to show that it's necessary. They have to show that you're making improvements. They have to show all these different things in order for you to qualify for those 100 days. But after that 100 days, it's a hard out. Medicare is not going to pay. So if you have a client who's going to be in skilled nursing for a period longer than 100 days, or they're going to be in a nursing home, that is not Medicare. They may qualify for Medicaid. Medicaid is one of the largest, I think it's the largest payer of nursing homes and skilled nursing facilities. The problem with Medicaid is that it is needs-based. So there are a lot of different requirements, and much like the SSI requirements, you actually need to have limited assets and resources and able to qualify for them. So there's a lot of attorneys whose main job is to help people qualify for Medicaid, particularly when they're going into a nursing home. So this is very specialized. I don't necessarily recommend that you dabble in this, but if you run into that issue, there are a number of attorneys who do quite a bit of it that you may want to speak with. And that covers Medicare. I went through these slides a lot quicker than I had anticipated. So while I'm happy to go back and cover things in a little bit more detail, I'm also happy to answer questions to try to fill out the rest of the program. So if anybody has any questions, I'm happy to take them either via the chat, or I can, I'd be happy to do it through the microphone as well. I'll give you a minute before I start talking about stuff in more detail. All right, anybody want me to cover a topic, specific topic in more detail before you make me pick? I see some divorce attorneys. I see some bankruptcy attorneys. I see some PI attorneys here. I'm happy to cover anything that intersects with your practice area. Okay. Oh, that's a good question. Yes.
Patrick, you mentioned that there's some manual that you consult frequently.
Yes. So yeah, that's called the POMS, which is the Program's Operation Manual for Social Security. That is readily available on Google. So if you just type in SSA POMS, P-O-M-S, that is what the Social Security Office uses for their details. There's a lot of gold in there because it tells you a lot of very specific examples of things. It helps you in just about every facet of the Social Security process. Can be laid out in more detail within the POMS.
Very good. Thank you.
Another question, what point should a client consider hiring SSDI counsel? And that's a good question. We get it a lot. So there's some lawyers that don't handle claims from the very, very beginning. Some lawyers will tell you straight out, I only will help you if your case is going to a hearing. Call me, file the initial application, call me if the application gets denied, and I'm happy to help you. A lot of people do that. Like, that's a pretty common approach for lawyers. I don't do that. I like to handle cases from the very, very beginning from a few reasons. The first is I like to make sure the application is done properly. So if you tell a client to do the application on their own, you run a very serious risk that it's wrong, that they either don't include all the relevant information, that they don't necessarily provide accurate doctor's information. You run a risk that the doctor's office is not cooperative, therefore does not provide the records, therefore the client gets denied. So there's a lot of things that can go wrong at the application stage, and I like to do my best to try to avoid that. A lot of lawyers will tell you, well, you're going to get denied anyway, so what does it matter if I help you or not? That's just inaccurate. That's a false perception of how this process works. A lot of people will tell you that you get denied no matter what at the initial stage. That's not true. They grant about 35 to 40% of initial applications, and I'd like to think that my rate's higher than that. Because we do spend more time developing the applications, and then we do make sure that the doctor's records are provided and things like that. So to ask the question, at what point should we get somebody involved? My answer is the earlier, the better, just because I like to have more control over the file. I like to make sure it's done properly. I can help the client develop the evidence. I have specialized forms that I have the doctors fill out. These are all things that help the case, build the case, and it really is important that you're doing that from the beginning. In my experience, clients are very reluctant to hire early on, only because they're always worried about cost. Every client, it's cost. Why am I going to pay you? And most clients think that their case is a slam dunk. Like, if you interview 100 people who are applying for disability, every single one of them is going to tell you, there's no chance I lose. And out of that 100, 65 of them are going to lose on the first try. Overall, probably about 40 of them are going to lose even at the hearing. So there's never a slam dunk case. It's a misperception by the client. And for that reason, when they are interested in hiring counsel early, I think it's a better move. I appreciate the question. If there's any follow-up on that, I'm happy to answer that as well. Let's see, next question. Pitfalls about ex-spouses claiming under ex-spouse's income. Yeah, I mean, the biggest thing that I'll tell you, if you're in a divorce and that matters to you, and it may not. Remember, if both spouses are working and they have about comparable income, or even disparate income but only slightly disparate, maybe one spouse makes 70, the other makes 50. That's not a big enough difference that you're going to want to collect under the other spouse's benefit. Because remember, you're not collecting their whole benefit, you're only collecting half. So if the primary earner was going to get $2,000 a month, and on your own, you're only going to get $1,200 a month, you're still better off collecting on your earnings record than your spouse's, because half of your spouse's $2,000 is only $1,000. So for most people, that's not going to be a consideration that you need to worry about. It comes up in the context where the incomes are really far apart, or one spouse didn't work for a large portion of the marriage, maybe from the time that their first child was born until their last child left the house, or maybe they never worked, or maybe they've been disabled for so long that they just haven't been able to. Those are situations where this is really going to matter. In those cases, the best advice I would give you is just read the rule 5 times to make sure that it's 100% correct. And if you still don't understand, just call me, because things that can get screwed up are you may not be married long enough. And in fact, I think I've worked with some of you on this, where we held back divorce decrees for a little while to make sure that they got their marriage was long enough to qualify for these benefits. The other thing you have to consider is for the surviving divorced spouse rule, you do have to be divorced for 2 years before those benefits count, or before you're able to access those benefits. So you may not be immediately eligible. In those situations, you need to consider bridging with like alimony or things like that to try to get people to that point where they can collect. For those of you who have worked with me on divorces, you know that I always try to do that. So I'm always constantly thinking about who's eligible for what benefits when, and are we bridging, and how are we doing this? So I'm constantly working on those things. Those are things you need to be thinking about. And if you're not at the stage where you're working with a divorce master and you're just settling, and you want to make sure that you're accounting for your client's interest, said double, triple, quadruple read the rules, make sure your clients are going to qualify, double check with Social Security what their benefits will be or what their projected benefits will be. Ask in discovery for what the spouse's projected benefits are going to be. Those things are now available very easily because you can make an account online at Social Security and get that information. You used to have to call and get a statement, and it was a huge pain, and now it's all available online. So have your client download their Social Security statement and request the opposing party's statement in discovery, so you have all that information available to you. You know whether your client's going to qualify on their own record. You know whether or not you need the opposing spouse's record. You know all of those different things. So in terms of pitfalls, knowledge is power. Make sure you know everything that's going on about the earnings record. Make sure you know what programs they'll qualify for and when, and then make sure you account for that in terms of the settlement. Can we talk more about how SSA goes after resources for extended nursing home skilled nursing benefits? Well, Social Security doesn't. It would be Medicaid. So what ends up happening is when you go over the 100 days, most of the time they'll have you fill out a Medicaid application because they want to get paid. And most health insurance providers are not going to pay for that. Maybe long-term care insurance will. Hopefully your client has long-term care insurance, but in most cases, people don't. It can be expensive and something that people don't like to think about, so most people don't buy it. So not a lot of insurance is going to cover this stuff. So what's going to end up happening is you exceed your 100 days in skilled nursing, they're going to have you submit a Medicaid application, and then if you just are disqualified, they're going to, I guess, give you some options. There's different things you could do with private pay. They may have you sell some of your assets to qualify. But really at that point, if you're in that situation, my advice is going to be go to somebody who knows what they're doing, because this is a niche within a niche. It's not something I even do. I refer all of these cases out to somebody who knows how to make sure that people qualify for Medicaid and make sure that they're doing what they can do to preserve the assets. Because much like I said about SSI, how you can do, like, keep a house and you can keep this and you can keep that, they have similar rules for Medicaid. And in the nursing home context, there are rules as well. So many times there's different arrangements that you can make with the nursing home that will allow you to continue to stay there or treat there, and not necessarily have to give away all of your stuff. Next question is, what Medicaid rules apply when someone is a PA resident but is going to a nursing home out of state? That's a good question. And my best guess, although it is a guess, Medicaid is a state program. Well, it's a federal program, but it funds through the states. So the issue would be, you normally would qualify for Medicaid through the county assistance office. So in this case, my best guess is you would use your domicile. If your domicile in that case is Pennsylvania, even though you're living in a nursing home out of state, that your domicile should cover you. But I don't know. And I will tell you that I would have to look into that. I would probably apply with the county assistance office for the county that I was domiciled in and see how they wanted to handle it. Any other questions about any of that stuff? The other thing I guess I can add here that I didn't really cover in terms of intersections with other practice areas, I guess there's two that I see very frequently. One is bankruptcy, one is workers' compensation. And I won't get into terrible detail because again, I can do a whole CLE on the interaction between Social Security and workers' compensation. But you do need to be aware there is a workers' compensation offset to the extent that you have received workers' compensation or settled a workers' compensation case, it may lower your Social Security benefits. People don't necessarily realize that can be true even if the injury isn't what caused your disability or what facilitated your retirement. So it's possible that you have a 40-year-old who's otherwise healthy, has a work injury, settles the case, and when they go to retire at 65 or 62 or something like that, they may end up with a workers' compensation offset. So it's important that you're aware that that could happen. If you're practicing workers' compensation, I'm probably not telling you anything you don't know. We typically account for these offsets within the workers' compensation settlements. And if you're going to be practicing workers' comp, you should know how we do that. The other thing I mentioned was bankruptcy. So with bankruptcy, the good thing about Social Security is that it is exempt under the federal bankruptcy exemptions. So for most of people who we're dealing with in bankruptcy, even if they're pursuing a very, very large amount of back benefits on a 10-year-old disability case, for most people, that's going to be exempt. Additionally, it's not included within the income calculations. So it's very favorable in the bankruptcy context. So we do like when clients are on Social Security, at least for bankruptcy purposes. And with that, I'm at 1 o'clock, but I'm happy to stay and answer any questions that anybody may have. And you can also contact me anytime, by the way. And I know most of you know that. Most of you I've already talked to about different things, but you can talk to me anytime, give me a call, ask me questions. I'm happy to answer anytime. I do this stuff all the time, so it's really not a big deal for me. So feel free to talk to me anytime.
Hearing no questions, I'm going to say thank you very much to Patrick. Another great seminar. All of you, just remember to turn in your CLE forms. Thank you very much. Everybody stay safe, and we hope to see you soon.
Bye, Denise.
Bye.